Curtis versus Chemical Cleaning and Dyeing Company, 1951. Principles involved. Misrepresentation in standard form contract. Now, what are the facts of the case? The claimant Curtis took her wedding dress to be cleaned by the defendants, the Chemical Cleaning and Dyeing Company. Upon purchasing their services, the defendants asked the claimant to sign a form, and she asked the service assistant what would be the consequences of her signing the document. The assistant replied that the form merely included an exclusion of liability clause for any damage they may cause to any beading on the garment. However, in actuality, the exclusion of liability clause pertained to all possible damages that may happen to a garment while it is being cleaned. When the claimant returned to pick up her dress, it had been damaged by the defendants and she thus brought a claim for damages against them. In response, the defendants submitted that she had no grounds for a claim due to the exclusion of the liability clause. Now, what were the issues in front of the court? The issue was that whether the exclusion of liability clause was binding upon the claimant, given that the service assistant had misrepresented its consequences. The Court of Appeal found for the claimant, viewing that though a party is typically bound by all the contents of a signed written contract, even where they had not properly read the contract, a clause ought not be deemed legally enforceable where the drafting party misrepresents the effect of a clause to the other party. Thus, the exemption of liability clause was not considered correct and the claimant was awarded damages.